Welcome everybody to the special launch event for the Just Security blog and for an extraordinary panel discussion tonight. My name is Ryan Goodman. I'm one of the co-editor-in-chiefs of Just Security, and this is Steve Vladeck, my partner in crime, and also co-editor-in-chief of Just Security. We appreciate people coming out, especially given busy work schedules with Congress in session and the General Assembly in session at the exact same time. And really appreciate specially invited guests from the Hill, National Security Council, State Department, the press, and other non-governmental organizations. In fact, the way we think about this is that you are our target audience. The concept that we had behind developing this blog and this project is that we want to be helpful in generating and interrogating ideas for people practicing on the front lines of these types of issues. And the concept for the blog therefore also generated the idea that we wanted to assemble kind of a dream team of legal experts on national security law, drawing in people who had been in the top levels of government, top lawyers, for example, from the National Security Council, State Department, Justice Department, and the White House, outstanding civil society attorneys, people from the Cato Institute, foreign lawyers, and legal academics. The idea is that Just Security doesn't have a unified voice or a collective viewpoint on any one issue. Any of our board of editors can post at will anytime that they like on an issue that interests them. But we also don't think of the blog as about the masthead, but rather primarily about our guest authors and the kinds of debates that we host and sponsor. So as you can already tell from the first few days of the blog that have been live and what's coming down the pipeline, we have guest posts and people that we really appreciate contributing to the blog, such as Michael Schmidt from a military perspective, and Jeff Korn and Eric Talbot Jensen also from a military perspective, and others such as Aaron Kerr, Gabe Schoenfeld, Faiza Patel, Jonathan Horowitz, Gabor Rona, Ambassador Cameron Munter, Luis Moreno Campo, and others. So the thought is that both with the masthead and the board of editors, but also these kinds of guests, the goal is that we can raise the debate and interrogate ideas in the way that I've described. But the thought is that we hope that we're already doing so, but we also wanted to just, as an example, flag that for tomorrow there'll be a special post by Harold Coe on the issue of U.S. goals in Syria, U.S. goals and strategy in Syria, as a kind of an example of the kinds of issues that we want to bring to the table. The idea for the blog is a shared vision behind this project, so there was a great deal of excitement for the people that we were able to draw together to be with us as members of the board of editors. And I wish that I could claim that one of us, in a sense, was the brainchild for this project, but in a way I think that we want to just give credit to two people in particular who did a lot of the intellectual heavy lifting. Sarah Nucky is a veritable founder of the blog. She's been key to the early development and is a constant course of sage advice for us in the life of the blog and dealing with national security law and the media in particular. And Harold Coe has also been one of the people who has been there from the start with a long vision and strategic vision of U.S. national security law and government. The goals moving forward for our vision of the blog, we thought we'd maybe identify a couple things. One is that we want to be more than just a blog. The idea is that we're also a resource for our audience and for our readership as individuals, which I think goes without saying, but maybe it's also important to make that explicit. And the second is that we don't think of ourselves as a competitor to others who share our goals, but simply as another vehicle for achieving them. So, for example, Ben Wittes and Lawfare have been extraordinarily generous with us. Ben has been very encouraging from the very moment that he was told that we were creating the blog. He has offered us his advice. He broadcasted an interview with Steve and myself on the first day of our launch on Monday, and Lawfare is also streaming the video of this panel tonight. So I thought I'd end just by saying that we're new and we are growing, and for that very reason, if not for just kind of the identity of our group, we value feedback. As we move forward, we value feedback from reporters, we value feedback from Hill staff, members of allied sectors. The vision for ourselves is that we require constant feedback of ideas to improve, as well as at the large level, as well as tinkering. We always look for new ideas, and the kind of the identity in a certain sense of the blog is that we're built on exposing ourselves to opposing viewpoints. So in fact, what we cherish most in a certain sense is disagreement, so that we can sort through our own ideas and interrogate them. So the thought is that we want feedback from and opposing views, everything from whether or not one thinks Guantanamo should be opened or closed or expanded, to what font size we have and the blue shade that we have in the background on the blog's page. So I just wanted to thank everybody for being here and thank our panelists, and especially also thank NYU Washington, D.C. For hosting this event.
Great, thanks, Ryan. So I'm just going to really quickly get us into our panel by introducing the moderator, who really probably needs no introduction, but I'll do my best to embarrass her anyway. Dahlia Lithwick is, among other things, a contributing editor to Newsweek, a senior editor to Slate. She got her undergraduate degree from Yale, graduated from Stanford Law School, and then clerked for the Honorable Proctor Hug in Portland on the Ninth Circuit. Reno.
New Portland.
Portland, Reno, same thing. And is certainly one of the most widely regarded and highly visible legal journalists, lawyers, somewhere in between, legal thinkers, and it's really a treat for us to have her moderating our panel for our launch event, When Reporting is a Crime, National Security in the Press, after Snowden and Sterling. So thank you very much.
Thank you very much. Can you all hear me with this strange device? Okay, so I want to thank Ryan, I want to thank Steve. Amazing building. And I just want to start by saying it's been a big couple of months in national security journalism. We've seen a huge uproar in the spring over news of DOJ snooping into AP phone records, going so far as to treat a Fox reporter like he may or may not have been a criminal. We've got new DOJ guidelines coming out that are going to purport to protect journalists and their records. And then we have a big decision by the Fourth Circuit in July in a case, Sterling, involving a New York Times reporter who is now either going to have to go to jail or be forced to testify about a confidential source. So there's a lot that's happened in a very compressed amount of time, and we're going to somehow endeavor in the span of an hour and a bit to poke through all that and see what it all means, whether it's time for national security journalists to freak out or whether the prevailing winds of reform and change are going to make things better. And the way we've decided to do this panel is to have three sort of mini dyads in which groups of two people talk a little bit conversationally on one of each of the three topics, with the caveat that we can all scream at each other as need be, but to try to unpack the three big issues and then circle back and talk about big themes. So I'm honored to be sitting on a panel with these esteemed individuals, and I want to introduce them very briefly with the knowledge that these are embarrassingly brief introductions. To my far right, Bob Korn-Revere, who is a partner at Davis Wright Tremaine and an adjunct scholar at the Cato Institute who specializes in First Amendment law. Welcome, Bob. Sitting next to him, Lucy Daglish, who is the Dean of the Philip Merrill College of Journalism at the University of Maryland, and formerly the Executive Director of the Reporters Committee for Freedom of the Press. And I should also add, in the interest of full disclosure, that I'm on the steering committee for that, and so Lucy's kind of my boss. Or my former boss. Sitting next to Lucy is Charlie Savage, whose byline I'm sure you all know. He's the Washington correspondent for the New York Times, who writes extensively on national security and national security issues. Now we're going to skip because we're going in alphabetical order, so sitting right over here is Gabriel Schoenfeld, who is a senior fellow at the Hudson Institute, former senior advisor to Mitt Romney, and author of the book Necessary Secrets, National Security, the Media, and the Rule of Law. Sitting next to him is Steve Vladeck, who I think you've already met, but in case you haven't, Professor of Law, Associate Dean for Scholarship at American University, and co-editor-in-chief of Just Security, which we are here to fet today. So congratulations. And sitting directly at my left, Kenneth Weinstein, partner at Cadwalader, Wickersham and Taft, former Assistant Attorney General for the Department of Justice, National Security Division, and former Homeland Security Advisor to President George W. Bush. So an amazingly esteemed panel and a very knowledgeable panel who's going to help us sort through a thicket of complicated questions about journalism and national security. So I want to turn to Bob and Lucy first. And I want to ask you to try, if you could, Bob, to set the table and talk a little bit about Sterling, about what the Fourth Circuit did and did not do in this 100-some page opinion. What changed? What didn't change? What's the state of play?
Okay. Thanks, Dahlia. I'll second the thing that she said earlier about it being an honor to be here. particularly for this event. For me, it's an honor to be anywhere because I'm in the last week of a 3-month sabbatical, so I'm still trying to get my head back in the Washington game. So if there seems like there's a 5-second delay to my remarks, that's the explanation, that's the excuse. As Dahlia said, it has been a remarkable summer, an amazing summer, beginning with the disclosures in May that the administration had issued subpoenas to get phone records on some 20 phone lines for the Associated Press in a leak investigation. That was followed shortly thereafter by the disclosure that James Rosen of Fox had been named as a potential co-conspirator in the violation of the Espionage Act, and therefore that using the affidavit to justify a surveillance order to get his email records. The notion of a journalist being a co-conspirator in violating the Espionage Act for committing acts of journalism was something that was really quite startling. This was followed shortly after that by all of the NSA disclosures, information that we would not have but for leaks of classified information, which has led to a series of continuing stories after that. And then followed in July by the decision by the United States Court of Appeals for the Fourth Circuit, United States versus Sterling, which held in a divided opinion that there is no reporter's privilege, either guaranteed by the First Amendment. This also, by the way, an investigation under the Espionage Act. No reporter's privilege under the First Amendment, not to reveal sources or to testify. No common law privilege under federal common law. And by the way, the majority added gratuitously, I thought, that if there had been a privilege, it wouldn't have been granted in this case. So a lot of stuff going on there. I think one of the things that I'd like to do in just trying to sort of set a background for this is to try and explain how this fits into a broader context, because for those of us who've been working in this area or following it for a long time, it really is part of a continuing story for which there have been no answers. It reminds us that when we work in the law in this area, that we're really riding on sand. No battle is ever permanently won. No battle ever permanently lost, hopefully. But we're also confronted with issues that go to the origins of what we think of as the discipline of First Amendment law. Now, obviously, there have been First Amendment cases beginning in the early decades of the 20th century, but in a book that came out this summer by James Goodale called Fighting for the Press, he really talks about people really thinking of the discipline of First Amendment law, beginning with the cases in the early 70s, Brandsburg versus Hayes, or the Caldwell case, as it started out at the New York Times, and obviously the Pentagon Papers case. And it's at that time that these two very important lines of authority began, and lawyers who practiced in that area began to think of themselves as First Amendment lawyers. The Brandsburg case in 1972, the Supreme Court held that there is no reporter's privilege. Although, as the dissenting opinion in the Sterling case said, have you tracked that opinion over time and how it's been followed? The result is clear as mud. That's because Justice Powell issued a concurring opinion that said that, actually the majority itself said that news gathering is not without First Amendment protection. The concurring opinion said that, well, maybe you should apply this balancing test. And the question in the cases since then is, do you apply that in every case, or do you apply that balancing test only in cases where there has been abuse by the government? Anyway, that began in the 70s. That was going on at the same time, Goodale reminds us, as the fight over the Pentagon Papers, which gets to the question of whether or not national security can justify extreme measures when it comes to restricting the press. In that case, the question was whether or not the New York Times and the Washington Post could be enjoined from publishing. But the question was left unanswered as to whether or not newspapers could be prosecuted for disclosure of classified information, for example, under the Espionage Act. For example, Justice White's separate opinion said the government's mistake here was that they went for an injunction. Maybe they should have considered other remedies. And so that has been an open question over the years as well. Those two cases in many ways are intertwined, both historically and in that context. But also we see in the events this summer that those issues are really coming together. The question of reporters' privilege and the question of what kinds of restrictions of the press are permissible when it comes to national security information. Now, we have avoided a real confrontation over these issues, I believe, over the years, largely because of forbearance. Forbearance both on the part of the government, because the government has not prosecuted journalists in the past, and also because they have adopted guidelines that bind, and Lucy's going to talk more about that, the Department of Justice guidelines. But interestingly, at the same time these cases were going on, the Department of Justice was adopting, and later in 1973 did adopt guidelines that limited when you could issue subpoenas for reporters. And as Adam Liptak reminds us in a great 1999 Law Review article, that this is sort of a shadow shield law. I mean, we don't have a federal shield law just yet, although we're making progress in that area, but that this will do until the real thing comes along. And he praises the Department of Justice for showing restraint in seeking materials that are arguably protected by the First Amendment. At the same time, I think we've avoided a confrontation largely because of journalistic forbearance, because quite often if you have this kind of national security information, responsible news organizations will, at the request of the government, consider and in the appropriate cases delay or withhold publication if it looks like there's going to be serious national security damage. And so we had this delicate balance going on for 3 or 4 decades where both the government and journalistic organizations were showing a great deal of restraint. We also had the situation with the Supreme Court in 1978 saying the First Amendment didn't prevent a search of a newsroom. Congress, 2 years later, adopted the Privacy Protection Act of 1980, which put limits on what government could do in that area. So again, it was part of a balancing act. But obviously the world has changed. It has changed in a number of important ways. Technology is the biggest change. We now have the global medium of the internet, we have individualized communications, we have access to unlimited amounts of information. And at the same time, the nature of world conflict has changed. The threats to national security have changed in the wake of 9/11. And this has also, in some cases, led to and also been associated with changes in the nature of journalism. Major journalistic organizations have faced threats to their economic future. They also face competition from a myriad of individual would-be journalists, citizen journalists, people who call themselves journalists, and there's a debate over even what that term means. And it has also led to the phenomenon of people who simply disclose information, in some cases indiscriminately. And so these are all forces that put pressure on this kind of delicate balance, this sort of détente we've had for 3 or 4 decades, leading up to this summer, where we now see that the administration has been going foursquare against leakers, both, and looking for members of the press to supply the missing information they think they need. With the AP subpoenas, we have the thought that journalists could be, at least the threat that journalists could be the subject of prosecution and not just sources of information. And that leads us then to the Sterling decision, which tries to come back full circle and look at those issues that were explored in the summer of 1971 and in 1972. We find that the decision itself is highly polarized. It's the majority written by Chief Judge Traxler basically just says there is no privilege. That if you read the Brandsburg decision, when Justice Powell wrote a concurrence, it doesn't matter that he had reservations in the concurrence or put caveats on balancing. He joined the majority, and the majority decision controls, and as a result, there is no privilege. And then went on to say that even if you looked at for the creation of a privilege by the federal courts through Federal Rule of Evidence 501, that we wouldn't do that either. There's no common law basis for a privilege for reporters. It doesn't compare to the other established privileges that have existed historically, so we don't find it there. But I think one of the most threatening parts of his opinion from the perspective of the press is where he goes through the factors that if there were a privilege, it would be denied in this case because, for one thing, it's obviously relevant to find out who the source of the information is. But secondly, there is no better source of information than the reporter. And he completely discounts the idea that there might be other sources of information, including, by the way, the phone records of the reporter and of the source, and detailing the number of times they talked to each other, at least those lines were used, and says that there really is no substitute for actually getting the source from the reporter, which means privilege would be denied in pretty much every case. You then have a powerful dissent by Judge Gregory, who says, well, in fact, there is a privilege, that Justice Powell's separate opinion did stand for something. It, as sort of, you treat the majority more like a plurality opinion, and as a result, you apply the rule of law that is supplied by that fifth swing vote. And in that case, he would have provided a balancing test, case by case, applying First Amendment principles, limiting to when you can compel journalists to provide this information. It is really as polarized as you can imagine on a decision that has been, or an issue that has been left open for all these years. Lucy will talk about the DOJ guidelines and the SHIELD law that are, oh, really? Okay. Well, someone will talk about those things. Great. And I find that even if we have, as we had in the wake of Brandsburg versus Hayes, where you have state legislatures stepping in and now perhaps the federal government stepping in with SHIELD laws, but the devil is going to be in the exceptions to these laws. And that in the end, all you can really rely on is the kind of forbearance that we've tried to rely on for the last 40 years. And that is, will government officials look to prosecute journalists using the exceptions that created whatever new regime we're left with, or will they try and be more solicitous of the principles embedded in the First Amendment? I think which way they'll go is sort of, you can see it going one way or the other, and the differing opinions in Sterling kind of show which could be one future and which could be the other, depending on what attitude they take. For example, the search warrant, the affidavit for James Rosen of Fox was brought under an exception to the Privacy Protection Act of 1980. So regardless of what kind of legal regime is set up, if there isn't an absolute protection for journalists, then you have to worry about what the exceptions are going to say, and whether or not you can rely on the law, or whether you really have to rely on the good faith and forbearance of the government officials, whether or not they're going to respect press freedoms. And so that's kind of where we've been left at the end of this summer and how it fits into the longer background of these issues.
So that's that's a really good background, and I wonder if, Lucy, you want to respond to this idea that, we've been in this kind of state of equipoise, and Sterling represents a watershed, and maybe, I know you've got some good backstory on Sterling.
I do have some backstory. It is a watershed. This case, I don't think people understand how old this case is.
Yeah.
And I think I will spend a few minutes just sort of talking about the highs and lows of the Sterling case. First, I want to say, Dahlia, when you were on the steering, I always thought you were my boss.
I wish.
I reported to you guys, and you were a fabulous chairman of the steering committee. I think it's important for anybody here who is not a journalist to understand that for a journalist, protecting your sources when you have made a promise is a core value. Just as a member of the clergy protects those confidences, just as a lawyer protects those confidences, just as a doctor protects confidences, while the law may not, as Bob pointed out, protect that, to a journalist, that is a core value. So you have to put all of this into that perspective. Why? Because we know that if you can't protect your sources, and it's become ever more apparent over the summer, if you can't protect them, your sources are going to dry up. And it's important for the public to recognize that the only way they can trust that a journalist has independent information and that they're not a representative or an agent of one party or the other is if they know that they are going to be able to make those promises to their sources. I think in years past, when I first got into the business of journalism and the law, there was a greater recognition of the value of independent news gathering. I have kind of watched that whole concept fly out the window over the last several years, and I think for that reason, Chief Judge Traxler's opinion really offended me and scared me more than just a little. I have seen opinions where judges came to that same ultimate conclusion, but were not nearly as dismissive of the value of news gathering in our society. I said this was a 10-year story. Wind back to, we go into Afghanistan in what, late 2001, early 2002, 2003, we go into Iraq. A reporter from the New York Times named James Risen starts gathering information about the National Security Agency. He discovers that the NSA is engaging in illegal wire gathering, wire tapping, whatever you want to call it. They're gathering information that we all have found out a lot more about over the summer. But they are, his sources tell them they are illegally doing this. He gets that story, talks to his bosses, the government knows he has it, and there becomes this almost 2-year-long conversation between the New York Times and the government about whether or not the disclosure of this information is going to damage national security. Eric Lichtblau from the New York Times becomes more involved in the story. The New York Times ultimately, in December of 2005, decides to publish this story. Meanwhile, the government is good and ticked off. And I think they have decided that they're going to figure out a way, I really believe this, they're going to figure out a way to get Risen. They ultimately, about 3 months later, Jim publishes a book called State of War. It is not published by the New York Times, it is published by somebody else. There are a couple of pages in there where they talk about the nuclear capabilities in Iran and some of the things that the government may or may not have been involved in that some people have said would identified some potential sources and methods for intelligence gathering, which infuriated the government even more. They impanel a grand jury in Virginia. One grand jury comes by. Jim gets subpoenaed. The jury tolls that 18 months goes by. They impanel another grand jury. At this point, Leonie Brinkma is the judge in the Eastern District of Virginia. Jim's very capable lawyers go in and they move to quash it. This case goes up to the Fourth Circuit and back, and Leonie Brinkma ultimately quashes the subpoena. And he gets indicted anyway without Jim's testimony. Come back a couple more years. They decide that they're going to actually go ahead with the prosecution. Right before the trial is set to start, Judge Brinkma issues an opinion that eventually was unsealed saying, well, I'm not going to force him to testify in the grand jury stage, but later on there might be reason to get his testimony at the trial. So the trial comes in, there's a motion in limine, they say they're going to call Jim as a witness. He agrees to testify as to the veracity of the story and about some threshold issues, but he's not going to identify his source. And the motion in limine is denied. And Jim is not, and Brinkma says, you know what, I'm not gonna make him testify. You've shown to me that you have other information that you can use. There are alternative sources of this information. She then says, and I have a transcript of it here, something to the effect of, okay, he's not gonna testify. Are you guys ready to go? Can we do this? How many days do you need? Can we be ready to start in about 5 days or whatever? And the government says, okay, Your Honor, we're set to go. A couple of days later, they serve some sort of notice saying that they're going to call 2 additional witnesses that apparently the defense has not been notified of, or they missed a deadline or something like that. She declares that they cannot use those 2 witnesses, and they say, Your Honor, if we can't use those 2 witnesses and we can't have Risen, we have no case. And so they end up taking it up to the Fourth Circuit. Now, at this point, it's already clear they think they can try this case without Jim Risen. They're ready to go. They appeal the two other witnesses, and we don't really know who they are. Most of all of that was done in secret. But I think in the end they said, well, what the heck, let's give Risen a shot. And they throw him into the Fourth Circuit appeal. So then you come up with the decision this summer where they get not only Jim Risen, but the other two witnesses too. We already know, because of what they said in Judge Brinkema's courtroom, that they don't need Jim Risen if they have these other two witnesses. I'm very curious as to how we're going to proceed from here. I don't think, I know this has been, of all the time I worked at the Reporters Committee and all the time I've been doing this, this is by far the longest Shield Law, reporter's privilege, source protection case that has been out there. It has been going on for 10 years.
Two administrations.
Two administrations. And it takes a toll on the reporter, it takes a toll on the publisher. The New York Times, to their credit, has been very, very supportive of Jim, but this is not their story that he is being subpoenaed over. He's got some sort of pro bono lawyers from Cahill who have been doing a marvelous job for him. And I know him well enough to know he's not going to testify. So we are really at a standoff here. I hope that we can talk further about the developments in technology that have really been a game changer over the last 10 years, both from the journalism side and from the government side. What the government can do to track a journalist today is far greater than what they were able to do 10 years ago. And the capability that the government has is really mind-blowing. At the same time, I'm not naive enough to deny that the risks for the government are much greater these days. Cybersecurity is a huge deal. It's a major problem both in the public and the private sector. And if I were sitting in the White House and the notion of somebody in the government leaking a thumb drive to me with hundreds of thousands worth of highly sensitive documents, would I be panic-stricken over this too? I'm not going to pretend I wouldn't be. This is an issue, and I get it. But I think in the Risen case in particular, we have to acknowledge that they don't need him. And I would be happy to talk more about that case later on.
Okay, and I should have said at the beginning, and I didn't, we're going to leave heaps of time for questions at the end. So to the extent that you are wanting to ask something, we're going to try to get to you. We're going to turn now to the Justice Department guidelines, which Bob promised that Lucy would talk about, but I think Charlie's going to talk about. And I think, Charlie, again, insofar as you can sort of unspool the basics of, what the proposed guidelines are and what the changes are, that would help get us all on the same page.
Absolutely. So as part of this recent sea change that other panelists have been discussing, one metric that hasn't been thrown out yet is that as of this week now, there have been 8 prosecutions of current and former government officials under this administration and for leaking to the press for public dissemination, if you count WikiLeaks as the press, and as opposed to 3 under all previous presidents combined. Although one of those 3 was during the Bush administration, and 2 of these cases, including the Sterling case, their origins in the last administration. So this is really the beginnings of this change probably began around 2004, 2005, and then pick up steam under this administration. And with each new case that has come down the road, there's been this sort of growing question of what's going on here? Is this deliberate? Is this just happening? And as best as I've looked into this a lot, as best as I can tell, it's mostly just happening because of the technological issues Lucy was alluding to. It's just so much easier now to look at a reporter's phone records or email records and see who was in contact, who had that information in the government. It used to be, they would say, hey, this leak was published in the newspaper, let's have an investigation. Step 1, who knew this information? The following 10,000 people. Step 2, close the folder, right? And now they can say, who knew this information? The following 10,000 people. Who of those 10,000 people has been in contact with this reporter over the last 3 years, and therefore they know each other? Well, these 7 guys. And then, well, we can look at these 7 guys and that sort of, and build a circumstantial case. The world has changed, and that's not going to change back. I think that that's the new normal that we live in. And so there's been this sort of growing, holy cow, 8 cases already, and we're only 5 years into this administration. Is this ever going to end? Is this going to roll back? Is there going to be a pendulum swing here? And so amid that anxiety in May, when we had the double whammy of the revelation that the Justice Department had secretly subpoenaed phone records for 20 Associated Press lines, entire bureaus, including bureaus where the reporters involved in that story hadn't even worked for 5 years, and had done so in secret without advance notice, so there was no opportunity for the AP to negotiate the scope of that and maybe bring it down to something a little more focused, or to ask a judge to quash it. And just as people were digesting that, there was the unsealing and revelation of the unrelated search warrant affidavit in the Fox News James Rosen, not Risen, confusingly, case, in which Rosen was portrayed by the FBI as a co-conspirator in violating the Espionage Act as a way to get around the legal prohibition on search warrants for reporters' materials. And so this came amid the sort of Benghazi bubble as well. And what was the other scandal of that moment?
Well, then Snowden came a couple weeks.
IRS. Yeah, so everyone was in an uproar in May, right? And this was one of the big 3. And out of that backdrop, Attorney General Holder looked like he might be forced to step down imminently, and instead he started meeting with media representatives and saying that he recognized something had gotten out of whack here and he was going to fix it. And they pushed out new guidelines that tighten the rules about when the Justice Department and under what circumstances will go after reporters, either for their testimony, like in the Jim Risen situation, or for their records, like in the Rosen and AP situation. And there's also notes, which would be sort of a third category of this. And the way the rules changed seemed to be clearly tied to these 2 revelations in May. So, for example, the new rule is, Holder said, we didn't actually ever intend to prosecute James Rosen of Fox News as a spy. We just said that to get around the legal prohibition on going after a journalism work product unless that journalist is in fact a criminal. But we didn't actually intend to treat him as a criminal except for this purpose, which is sort of a bad faith gamesmanship, right? And so the new rule says, no, we're not going to do that. Unless there is in fact an intent to prosecute the journalist, you don't represent to the court that the journalist is a criminal in order to get around this statute. And if we are going to invoke exceptions like that, there's going to be much higher level review. The Attorney General himself must sign off after a lot of bureaucratic process. And on the AP matter, it was the lack of notice that really made that controversial, with the derivative issue that if there had been notice, it probably would not have been so arguably overbroad. There would have been negotiation over what do you really need here. And so they shifted the presumption from we won't notify unless there's a good reason to we will notify unless there's a reason not to do so. And also higher level review if they're going to invoke that. So this is sort of small nudge style changes. Maybe the Rosen one about not portraying a journalist as a criminal unless you really mean it, the most significant there, because that was the most, I think, from the journalistic point of view, the most alarming development. It was suggested that this crackdown on leaks was about to go to a whole new level, that they were, in fact, going to prosecute a reporter, which has never happened in this country. Still, though, I think even the Justice Department, even Attorney General Holder, who wants very much to be seen as a champion of this stuff now, not the foe of the First Amendment that he was accused of being in May, acknowledged this is modest and that the real change would be the passage of media shield legislation, which this administration has now thrown its weight behind. The main difference being that if the Media Shield legislation were to become law, it would ultimately not be up to the Attorney General about whether to issue such a subpoena for phone records or so forth. It would be up to a judge. And that's something that can't be done unilaterally by the executive branch. Congress has to enact law to make that happen. That would be a big deal. This stuff is more modest than that. I'll stop it there.
Well, does somebody want to briefly talk about the Media Shield law, where we're at with the proposed Shield law? Lucy, do you want to just...
Sure. Well, a couple of weeks ago, we were able to get, or the Media Coalition that had been working on this for most of the last decade, was able to get an amended version of a Shield law through the Senate Judiciary Committee. And the hang-up for the last 5 years or so had been over the definition of who would be considered a journalist and entitled to the coverage. The holdup in that particular area really was Dianne Feinstein. And by negotiating with her and her staff, I think they came up with compromise language that would clearly cover most run-of-the-mill reporters who are working in a rather traditional way. It would cover independent journalists who can demonstrate some sort of a track record. It would cover student journalists, and it would cover people that, kind of the last Hail Mary thing. It would give discretion to a judge to declare someone to be a journalist. And quite honestly, over the last 25, 30 years or so, judges have done a pretty good job of deciding who's entitled to a privilege and who is not. That was the biggest stumbling point. This particular law, without going into great detail, provides a framework. It would be difficult to get a national security subpoena quashed, but not impossible. It provides a mechanism to make the argument to a judge. I think on the House side, a Shield law has passed the House twice, I think in 2007 and then also in 2009. I don't think the House, even though the House has flipped since then, I don't think it's going to be a huge problem there. And the Senate version will be the operative version that ends up in front of Congress. And at this point, as we discovered really the last time we got sort of this far, it's now a matter of convincing Harry Reid to get it on the floor. Because those of you who cover Congress or are familiar with how Congress works, there are a lot of procedural things that can happen in the Senate that can hold up a bill even if everybody agrees it's a really terrific thing. And that's where we are. We need to convince Harry Reid that this is something he needs to make a priority and actually push it to the floor.
Great. So we're going to turn to you, Ken, and ask you, you're in the unique position of being able to tell us how the new proposed guidelines would impact a leak investigation. What are there, in fact, real changes, and how does that play out?
Yeah, let me just sort of take it back to the fundamentals for a second. I mean, I think implicit in everybody's comments is this, there are two major values at stake here, right? There's national security on one side and then freedom of the press, what is a fundamental value of our democracy on the other, and there's a tension. And where you stand on this issue often is based on where you sit. And I think you can look at any one of these issues, and if you're fair-minded, and I try to be, and I think we all try to be up here, you can see both sides of the issue. Just to take the Fourth Circuit case that Lucy just described, I mean, I, coming from a national security background, see that case a little differently than she described it. I mean, first I look at the substance of what was leaked. I mean, this is about the Iranian nuclear program, one of the greatest risks that we face. I mean, really serious stuff. That's an important factoid in thinking about what the government, assessing what the government did. Another factoid that I think is interesting, is important to keep in mind. My understanding is the New York Times, Bob talked about responsible press organizations showing forbearance and not publishing things where the damage would be too great or be outweighed by, would outweigh any public interest. They took a pass on this, didn't publish it. Verizon decided to go ahead and do so in a book. And as far as I can tell, I don't see anything really all that valuable about that specific information getting out to the public other than it's a neat story about government covert operations, but it's very damaging. I mean, it's unlike the examples that Lucy used about other disclosures of, in the 2005 range about programs which, people arguably thought were illegal. So this, I think qualitatively, this leak was different than a lot of other leaks. And then and I'm not involved, haven't been involved in that investigation or prosecution at all, but just looking at it as a former prosecutor, if I'm being told, well, we're going forward to the Fourth Circuit and I'm deciding what to appeal on, I mean, as Bob said at the outset, who's the person who best knows who the leaker is, right? That's the reporter.
No, that was Judge
natural
Traxler.
What's that?
That was Judge Traxler, not me.
Okay, well, Judge Traxler said that. But it's true, and so if I'm a prosecutor, I'm thinking, who do I want to put in front of that jury? Who is the jury going to say they want to hear from? They're going to want to hear from the person who was the leakee, who heard the leaked information. So to me, it's a no-brainer, especially given that there's no reporter's privilege. If you're trying to put that case together, I would want that reporter on the stand. And especially given the backdrop here, I'm not surprised that was the decision they made. I lay that out just to show that I think reasonable minds, people who have the same concern for national security and the First Amendment, can sort of see these issues differently. In terms of the impact that the DOJ guidelines are going to have, I don't think they're going to have the revisions to the DOJ guidelines. I don't think they're going to have a dramatic impact because what Bob said at the outset, I mean, the DOJ has shown forbearance over the years. This isn't a situation that they've been going hog wild against reporters. I mean, a relatively few subpoenas to reporters for source information over the history of our country. Never prosecuted a reporter, a journalist, for a leak case, even though the law clearly, there's no reporter's privilege, and the law allowed subpoenas in cases, lots of cases. And there were many times where they could have gone ahead and prosecuted a reporter. I mean, keep in mind, under the Espionage Act, a reporter who receives national defense information and with the sufficient intent discloses it can be prosecuted. And we talk about the Rosen matter, and Charlie sort of talked about how that the affidavit in support of the search warrant characterized him as being a criminal. He said that was to evade the statutory intent. It actually was an element. It was a requirement of the statute in order to get a subpoena directed at somebody who was violating the law. And under the law, based on the facts as I know them, and I saw them in the affidavit, he was violating the law. That's a different question from whether the department is going to prosecute him for doing so. And that gets back to the forbearance. The department has never done so. Eric Holder was very clear from the day one when this came out. We didn't intend to prosecute. We were just satisfying that element of the statute. So that's never been an issue. And one of the reasons, one of the manifestations of that forbearance has been the articulation of the guidelines, which I say were put in place in 1973 or whatever, but they certainly were there well before I became a prosecutor in the late 80s. And those guidelines have always required that a prosecutor can't seek a subpoena of a reporter unless they have reasonable grounds to believe that the information the reporter has is essential to a successful investigation of a crime, that the prosecutor has made all reasonable attempts to get that information through other means other than subpoenaing the reporter. And going back to the AP case, I think that's the case was made publicly, I believe, by the government that we did in fact try all alternative means, reasonable alternative means to get the information. Once we realized we couldn't do so, we then resorted to getting a subpoena. The prosecutors always had to seek the voluntary cooperation unless, and this is a big change to the guidelines, unless there's reason not to give notice. And now the new guidelines establish a very strong presumption that there will be notice to the news organization unless very demanding criteria are met. And then it's always been the case that that request got reviewed all the way up the chain of the Department of Justice to the Attorney General. And that protocol, which has been in place for decades, is the reason why you haven't seen that many of these kind of subpoenas. So I don't think that this is going to have a dramatic impact on the status quo. I mean, it obviously raises the scrutiny of any request for a subpoena, and that's a good thing. I think on the margins it might have an impact, especially like on overbreadth. Like the AP case, and I don't know any facts other than what I read in the newspaper, but they asked for 20 lines. And whether all 20 lines, somebody really asked all the tough questions. all 20 lines could have been justified or not. I don't know, but I think you'll probably have a lot more scrutiny paid to these requests, and on the margins, I think they'll probably be narrowed. But I don't think you're going to see, just because these guidelines were, I don't think these guidelines signify great, dramatic backing away from the effort to prosecute leaks. The media shield law, a different story. That, I think, could frustrate the effort to get subpoenas, and also could dramatically delay investigations. Now, keep in mind, leak investigations are usually not ones, it's not like a terrorism investigation where you're trying to stop an impending terrorism attack and time is of the essence. Sometimes it could be, depending on the circumstances, but usually we'll have time. So delay might not be fatal, but still, it could delay things, and one of the reasons why the case of the First Circuit has taken so long is because of all the litigation about the subpoena to the reporter. So I think if there's a media shield law, you are going to have some delays, and there'll be cases that the government is just not going to be allowed to bring because the judge is going to assess that the government's interest in prosecuting the case is insufficient. Anyway, so I think that, back to Bob's original point, in looking at this debate, you can think of a parade of horribles. Think of what the government can do, what is conceivable that they could do, and the impact that would have on reporters. But look at what they have done and the forbearance they've showed, and I think that is instructive on what kind of law, what kind of limitations need to be placed on the government.
So we've got 3 strands of conversation going. We've talked about Sterling, we've talked about guidelines, we've talked about the proposed media shield law, and now we're going to turn to Gabe and Steve and ask you to make it all make sense and just kind of tell us the meta.
No, I think
No.
I'm going to depart from that
Okay.
plan and talk a little bit about the 2 cases. But we're to go back to something that Charlie said, we have these eight prosecutions. It's more than double all previous prosecutions in our history. It's interesting to try to account for that. Charlie offered the technology, and I think that's clearly true. But I also think that a strong case can be made that there's frustration in the government. The Bush administration, it began, and then the Obama administration as well, with the proliferation of leaks, with leaks that are of a different quality than leaks in the past, in the pre-9/11 era, leaks of highly sensitive national security information, top secret information that does do grave damage. The information that James Risen put into state of war, which the Times was warned not to publish and agreed with the government's warning, something they seldom do, the point that Ken made. I think it's very striking. So I think that it's not just technology, but a real change in ideas about the legitimacy of leaking and then also about the press's role in publishing leaked materials. Now, in all these fascinating cases that have arisen, I think 2 things strike me as particularly significant. And one is the Obama administration's decision to level a charge against Bradley Manning of aiding the enemy. Now, this really is, I think, a very dramatic and I think unfortunate development. I think by the logic that they're using, which is that since he provided information to WikiLeaks and then it was Osama bin Laden and others in Al-Qaeda could then read that information when it was on WikiLeaks, he had somehow aided them, and that was his intent. By that logic, just about every leak that appears in the New York Times or any other place could also be considered aiding the enemy. And I think Congress, in passing the Espionage Act, did want to distinguish between that kind of outright treachery and the lesser crime of disclosing classified information. So that's one area where I think fairly significant. The other is to return to this James Rosen case, the affidavit naming him as a co-conspirator in a plot to violate the Espionage Act. Now, I think it's important to note what James Rosen was doing and what led the FBI to describe him in that way. He was communicating with a State Department contractor employee whom he had cultivated as a source. He instructed this individual to convey to him, he asked him to convey to him internal State Department and other intelligence documents. So he was soliciting the information, but he was not only doing that. He was instructed him that they would communicate using aliases and in code. Now, the FBI says, okay, that makes him look like an intelligence operative running a spy ring. Journalists and their defenders are outraged by the idea that he's described as an intelligence operative. Yet his behavior is functionally identical to that behavior. I'm not saying that he was committing espionage, but from the point of view of law enforcement looking at this, how could they not conclude that something is afoot? Because an interesting, a complicating part of this is that he's claiming that he has the right to do this under the First Amendment, but because he's a member of the press. But one has to ask, who can be a member of the press in this country? It's basically anyone who conveys information or opinion in some medium. So one has to ask whether if James Rosen is entitled to communicate with government officials, highly cleared government officials, and solicit classified information from them, communicating in code and using aliases, can reporters from other outlets do that? Can, say, reporters from The Guardian? Or how about Al Jazeera? Or how about another paper like China's People's Daily, the organ of the Central Committee of the Communist Party, when they have a bureau in Washington? So I think that's a very fraught practice that he's engaging in. And just as the government has engaged in forbearance towards journalists, I think the press needs to engage in forbearance when it comes to some of these practices. Otherwise, we do risk the problem of indictments of reporters, which I think would be a terrible thing since it's never happened in our history, and it would break press. So we need forbearance on both sides, and that's the problem with James Rosen.
So I suspect Steve wants to respond to that.
Well, I mean, I think, let me see if I can simultaneously respond and sort of take us a bit to the meta, if that's possible. I mean, I think that the hard question here is really provoked by the Espionage Act. If there were not this incredibly capacious, vague, ambiguous statute that could be invoked, whether with malice aforethought or not, as the potential basis for the liability of a journalist, whether or not the Attorney General meant it or not, right? That's the lever that's doing the work here. And I think one of the hard questions here is, what would we do differently, right? If Congress had to start over, how would it create a regime that actually balanced the values that we're hearing about? And because it seems to me that the equipoise, the very famous 1973 Columbia Law Review article by Schmidt and Edgar called it the benign indeterminacy of this issue, has been with us since they wrote it. And I think the hard question is it a benign indeterminacy with which we're comfortable? Is there actually a world
is it still
where
benign?
Was that?
Is it still benign?
Well, and is it benign? I mean, I think that's part of the answer to are we comfortable with it, right? Is it benign? We have statements on both sides, right? We have members of the press saying, well, this is a really heavy sort of Damocles hanging over us, right? It's not that benign if it's being invoked the way it was, for example, over the summer. We have people like Tony Lapham, right, who is the general counsel of the CIA, who testified in 1979 that the indeterminacy is actually really bad from the government's perspective because they can't be sure of just how far they can push the envelope in a relevant case. And so I think the really, really messy question here is not sort of how do we balance these values, but how can we better balance these values? And is the law in its current form between the proposed Media Shield law, between the sort of capacious but never applied to a reporter Espionage Act, is that actually a balance that is better than the alternative? And in that regard, there's one piece of the conversation that I'm surprised hasn't come up yet, which is, I think, another possible reason why we're seeing all of this pressure now, which is overclassification.
Yeah.
Right? I mean, I think, the folks have been saying for decades that we have a serious problem in this country when it comes to overclassifying government information. Everyone's going to have their own view on where the right line is between overclassification and appropriate classification. I do think part of what is going on lately is partly triggered by this sense, whether by the public or by the leaker or by the recipient of the leak, that there's all this information that's being classified that shouldn't be. and that should never have been. And we can sort of quibble over what each leak and whether each one of those fits into that category. Certainly we saw in the Manning disclosures to WikiLeaks, right? Thousands of government cables that didn't need to be classified. We're seeing now with the release of the Foreign Intelligence Surveillance Court opinions that maybe had to be redacted, but otherwise never needed to be classified. Right, and so I think part of what's going on here is these three different pressures, right? A concern that there's too much secrecy, a concern that the press might be pushing the envelope too far, and a concern that the government might be pushing the envelope too far. And the question is, are those three exerting equal pressure to keep us in a benign indeterminacy, or is it becoming increasingly less benign? And I think, the only way to answer that is to ask ourselves what our value system is. Right, at the end of the day, if we have to err in one direction, which way do we want to err? Right, and so the government's practice historically, as Ken rightly says, has been to never ever pursue an indictment of a reporter under the Espionage Act, even though, mind you, one of the provisions of the statute was enacted in 1950 specifically in response to the Chicago Tribune's publication of the fact that we broke the naval codes of the Japanese fleet, and that's how we won the Battle of Midway. Right? Is that a world we're happy with? Or would we prefer a world where there are clearer answers to this question? And so let me just sort of wrap up by sort of tying this back to the First Amendment, which presumably is what's lurking in the background. Potter Stewart said in this famous 1974 speech at Yale Law School that the First Amendment is neither a Freedom of Information Act nor an Official Secrets Act. Right, that the press has a right to try to obtain government information and publish it, and the government has a right to try to stop them. And I think the question is that just sort of a reflection of the same phenomenon? Or should we actually think about a First Amendment principle where, for example, it's protected speech to publish information that should never have been classified, or it's protected speech to publish information that may have been properly classified, but where the public interest in knowledge of the program dramatically outweighs the cost of public disclosure, and that's sort of akin to what the old Pickering test in First Amendment jurisprudence. Or do we want a First Amendment that just provides no protection whatsoever in this context? That's a question that's ultimately up to 5 Supreme Court justices. Well, 9, but 5, 1. Right, but I think we have to, if we're trying to sort of come out from the summer and ask what the state of this conversation looks like after Snowden, I think what it looks like is, are we going to do the same thing we've done, which is every time there's a major leak, have this big reaction, have Ken and Gabe and me called to testify at the same hearing that Congress has had on like 11 different occasions, right? Or are we actually going to try to change something? And I think the answer to that has to depend on where we actually decide our First Amendment values lie at the end of the day. My own personal view is that I think there should be, at least more protection for reporters, but I'm just a law professor. What do I know?
So I think I want to have Lucy and Bob just have 1 minute to respond if you want to respond to what you've heard. Not
to all my provocations.
Well, to everything that's just in the interest of, because you spoke first, and then we'll kind of let you all respond, and then we'll take questions, I think. But an awful lot has been raised about technology and about whether reporters have changed and whether the Obama administration has changed, and why don't you just pick a horse and ride?
Well, let me start with the word forbearance, since I injected it into discussion, and it seemed to be a very popular word. And I think it is a word in a context, and in the context of Adam Liptak's 1999 article, it made a lot of sense. In the context of the summer of 2013, not so much, when you're talking about a world in which there are 8 prosecutions now under the Espionage Act of leakers, and the threats that can be extended to reporters. Obviously, where there is universal access to the internet, and the idea of documents simply being dropped there, the notion of press forbearance is also kind of quaint. It's hard to put the toothpaste back into that tube. So we're sort of, in many ways, beyond the world of forbearance. That's difficult when you talk about the Justice Department saying we're simply interpreting the law to name reporters as potential criminals because that's what it permits. If you read the Espionage Act as an Official Secrets Act, I can see getting to that interpretation. But if you read the Espionage Act as a law to prohibit spies, it's less obvious that you would put in an affidavit that someone is aiding and abetting a crime because he's committing an act of journalism. And so that all is very difficult. I think what emerges from all this is we all understand, I think everyone agrees, there are real issues on both sides of the debate. There are two sides, at least two sides, many sides, that all have valid points. And it's easy to see the national security side. You think of 9/11, you think of all of the horrible things that have been done as terrorist acts, and you think we can't allow that to happen, so we need to protect national security. That side of the debate is very tangible. It's easy to picture. It's less easy to imagine what if we lost, if we force reporters to give up their sources, or if we force the information. And fortunately or unfortunately, the leaks that we've seen for the NSA information has shown us what the price of secrecy has been. I mean, we're learning for the first time, only because of these leaks, about the extent of the surveillance operations. And if you look at that in the context of privacy law in the United States over the last 2 decades, you begin to see that this really is big stuff. This is really important. I mean, think of one of the main controversies under the Clinton administration in the mid-90s when they wanted to install a clipper chip in people's computers. They wanted to maintain the ability to conduct surveillance as we went to a digital world. And so they proposed allowing this sort of technological fix to permit that. That led to a lot of hand-wringing, led to a big congressional debate that led to the ultimate passage of CALEA. But still, the thought of having the government with a backdoor into everybody's computer was huge. Then there was the carnivore issue, which case that I was involved in, where the government wanted to use trap and trace, that part of the Electronic Communications Privacy Act that was written for telephones, or actually it was earlier part of the 1968 Omnibus Crime Control and Safe Streets Act, but designed for trap and trace devices for telephones, just to get phone numbers. They wanted to use a software patch that could use that for email. That ultimately got written into the law with the Patriot Act. But all of those things that were legal controversies at the time, we find now through the NSA have essentially been done without our knowledge, without public debate, through the back door. And so the disclosures that we now know because of the leaks, and of, I think what you would say is even legitimately classified information, I think are very serious matters that deserve a full airing in a democratic society. We now hear James Clapper say that it's time to have this debate. It kind of would have been nice to have had that debate before these things took place.
Or when they were reauthorized.
Yes.
Yeah.
Do either of you want to respond either to that or to Steve's framing, or should we open it up? Okay, so I think we've got microphones in the back of the room, and I think if you want to ask a question, I beg that it come in the form of a question, and if just kind of signify if you want a mic, and if you want to ask either about what's happened or something that hasn't been raised, we'll try to do our best to respond. Okay.
Hi, I want to thank you for bringing up the SHIELD law and just bring up a point that was actually made yesterday in the Columbia Journalism Review, and that was regarding some of the criticism that the amendments to the law have faced, especially by members of the blogosphere. And I was curious to get your feedback just on some of those critiques, one of which is that just presenting as a hypothetical may treat like individuals in this audience who are tweeting this event and say Mr. Savage differently for purposes of the SHIELD law.
Do you want to direct that to someone in specific, or do you want someone to just have a go?
Probably Professor Vladeck and
I was trying to duck, but it's hard to duck on stage. You know, I think the hard question is, what is the value of codifying a distinction between members of the press and everybody else, right? And you know, I think this is part of why the Supreme Court has steadfastly refused on every possible opportunity to actually give any constitutional significance to the distinction between a paid professional journalist, an amateur journalist, and some guy with a newsletter. Partly because Thomas Paine, right, was some guy with a newsletter. And so I think, I think the tricky part is, I don't know how you create a shield law without at least some definition of who can invoke the shield. I guess I'd be happier in a world where the shield was defined not by the identity of the person who was invoking it, but by the nature of the communication that was ostensibly being protected. And I think that would be a sort of, a less fraught way to do it, but Lucy's probably thought about this longer.
Yeah, there's a difference in a definition, and if you can come up with more of a function test rather than a status test, you're in better shape. The Senate version of the bill has always been more of a function. What was the function the communicator was playing at the time the information was gathered? What if it involved confidential sources or information? And by the way, the federal shield law will only cover situations where you are trying to protect the identity of a confidential source. And so what were you representing to your source you were going to do? And at the time you made that promise, was that your intention? And if that was the function you were playing, or you were doing, then I think you're going to end up being covered under the Senate version of the law. And when I was at the Reporters Committee, that was always the organization's stated preference and what we always pushed for, so that someone who was out there routinely tweeting, you come to a conference like this, you hit every national security conference in the world, and you're out there and you're communicating and you have an audience, and people know that they're going to be able to rely on the information you gave, you're going to be able to argue to a judge that you are covered under this function test. And I think that's about as good as we can do. Is it perfect? Heck no. Charlie and I were on a panel discussion last week where we got, pilloried by Scott Armstrong, who's a dear friend, and is one of those people who believes that, the First Amendment is all you need. Well, I increasingly, I was a journalist, and I was a trial lawyer, then I was a nonprofit lawyer, and now I'm back to being an academic, and I'm trying to play all these different roles. But when it comes right down to it, and I took those phone calls at the Reporters Committee and somebody was in trouble, I looked at it like a lawyer. And when you're a lawyer and you've got somebody in trouble and they're coming to you and they say, what can I do? You're going to try to get as many tools as you can. I've also been a newspaper editor. And let me tell you, when you've got somebody in your office and they come to you and say, I've got this subpoena, you're going to look at it and say, what can I do to help you? And if we can knock out particularly the subpoenas on these, what I consider to be odious Privacy Act cases on the civil side, and the bulk of the subpoenas that come in the federal courts, which are actually out in the rest of America, where you have reporters who are probably never going to do a national security story, this is going to be enormously helpful to them. And so I think this falls under the category of you do the best you can.
I think it also begs the question of how the new DOJ guidelines might fit into that, because it seems like, loath though we are to draw a distinction between what we might think of as conventional print media and new media, it may well just be the case that more often than not, the cases that are going to arise that test this are what we might think of as more typically, not conventional media, but sort of mass media, right? WikiLeaks as opposed to, neighborhood blogger. And I guess the question is whether that might also, whether the sort of the mentality that DOJ needs to show a little more restraint that there's, whether that's going to fit into this at all.
And the other part of the definition you need to understand about the function, if you are someone who takes a big bunch of documents and dumps them out in the law is not going to cover you.
Hypothetically.
If you do something creatively to them, I'm just talking about the way the surviving bill ends up. If you are actually out there doing some journalism and you are taking this information, you are digesting it, you are interpreting it, you might make some follow-up phone calls, you might gather some other information, and you are going to do something to it, something creative to it, you're going to have a much easier time convincing a judge that you are a journalist than if you take the documents, put them on the internet, and don't do anything in the middle.
Sort of like national security fair use.
On that point, if I were Julian Assange and I saw that definition, I would start doing a little bit of interpretation on my site, and I would get the
That's what, having known Julian Assange's lawyers, I can tell you from data release 1 to data release 2, they started doing some creative things to it. Then by the time the State Department documents, they were getting a lot more creative. They were doing more journalistic type things, and they were advised to do that specifically by their lawyers who said, we know a little bit about American law.
So do they fall under the privilege of the Shield Law? Would they benefit from it under the definition?
If they were taking it and the people who were doing that particular work, they'd have a shot at making the argument.
Let's take another question.
Hi, this is for Mr. Weinstein and also for Charlie Savage. Mr. Weinstein, you mentioned that though the government has come close to prosecuting journalists, they haven't actually done so. Doesn't just the fact that the possibility of prosecution actually exists isn't sort of the damage done just by that? And I want to ask Mr. Savage what the impact has been of this on journalism itself, on reporting.
Well, as to your question about whether the specter of prosecution is chilling the press, the specter of prosecution without any examples of actual prosecution, I don't really think so. I mean, I think we see leaked information getting in the press all the time. And I think if you were to put Charlie Savage on the box and ask him to say, does he live in fear of being prosecuted, I think he'd say no. Because it just isn't going to happen. So I'm not sure that it really, the fear of actual prosecution, handcuffs on the reporter going into court and being prosecuted for disclosing national defense information, classified information, in the press. I don't think that reporters are really concerned about it. Now, the only time that the government came close to that was with the AIPAC prosecution. You recall
Also called Rosen.
Yeah,
Also
Rosen.
called Rosen, yeah.
And there actually I think reporters really were concerned about that, because what that was is there are two gentlemen who work for AIPAC who were indicted on federal charges for having received information from a government employee, from a Pentagon employee, and then disseminating that to foreign government and to the press and to others. And so they were prosecuted for that receipt and dissemination role, which of course is analogous to what a reporter does. Not a reporter, not reporters.
But the first time you ever had a third party being prosecuted.
First time that the leakee got prosecuted as opposed to the leaker. And that case ended up going down the tubes for a variety of reasons, legal and otherwise. But that's as close as the government's ever come. So I think that it's obviously something that reporters, I think about, and maybe in a time of war, maybe if we had another Chicago Tribune situation where we were actually, there are secrets of that value being disclosed in a time of war, when people are a little bit more, maybe less concerned about the First Amendment, more concerned with winning the war, then maybe that would be a realistic possibility, and I think reporters might be more chilled by the prospect of prosecution, as opposed to being chilled by the prospect of being hit with a subpoena to disclose who your sources are.
Well, so do I live in fear of being prosecuted? I agree that I don't live in fear of being prosecuted, but it's not that simple, because things are changing right now really fast. And it's not like we've reached a new equilibrium as far as I can tell. So no reporter has yet been prosecuted, but if you go back just a few years, no government official is getting prosecuted either. And suddenly we've got 8 cases in this administration, plus the Rosen AIPAC case, and some other cases that didn't work out but almost did in the second half of the Bush administration. So where is it all going to settle down? And 2 years from now, I might have a different answer about whether I'm in fear. And certainly I don't particularly have a huge amount of confidence in my electronic records. Of course, probably no one does at this point.
It's a really important point.
Yes.
But it's also not just about like me. It's about my ability and people like me to do our jobs. So to take the most interesting, in my opinion, of the Snowden revelations, right, which is the metadata program. Everyone's every phone call is being recorded, not recorded, but a record of it has been kept. So that's the big Patriot Act revelation that Senator Wyden and Udall were hinting about for some years.
Yeah.
I spent, and a couple of my colleagues, Scott Shane and others, spent a lot of our life over sort of a 2-year period trying to figure out what the heck they were talking about. We fought a lawsuit to do it the right way through the Freedom of Information Act. That didn't work too well, to try to figure out what that was. At least tell us the legal theory you're playing with, if not what you're doing with it. No, the government can keep its legal theory secret. I talked, I'm sure, to 30 or 40 people who knew what that program was, and people who told me they knew what it was, but they weren't going to tell me because, they've got kids, and people are going to jail left and right now, and it's not worth it. I think that but for this turn, we would have figured that out without Snowden feeling the need to dump that out, or along with the other 20,000 documents that he dumped out while he was at it. But it may have been that very thing that sort of instigated him to think that some huge secret was being held away from the American public that just wasn't coming out any other way, despite the Wyden and Udall vague hints. And this, I think all this feeds in as well to the overclassification anxiety and the sense that especially Bradley Manning and Edward Snowden, are different animals than the ordinary leaker who hands over one document or a particular piece of information. This sort of mass pressure valve release that gushes out from the Bradley Manning model, Chelsea Manning model, and now Edward Snowden as sort of the next example following in that path, is coming against these pressures that are mounting as reporters have a harder and harder time doing it in the traditional way.
I think there's also, I think there's one more thing that's happened, and I think this is sort of last on the totem pole, but not irrelevant, which is in 2006, the Supreme Court tore a big chunk out of government employees' First Amendment rights.
Yes.
Right, so in the Garcetti case, I think, Garcetti was not a national security case, and so we tend not to sort of put them in the same conversation. But, there is a perfectly plausible reading of Justice Kennedy's opinion for the court in Garcetti that government employees never have First Amendment rights in speech that they are able to undertake only by virtue of their government employment. And so, right, Charlie's point about sources drying up, I think is both tied to the prosecution piece of it and tied to the, I think indirectly, at least once you talk to the First Amendment lawyers, the unavailability of defenses that might have been there previously. And I think that's another piece of this conversation.
And the other part of it, too, is that normal institutions of a democratic society really aren't functioning in the way they normally do when there isn't such secrecy. And so you have congressional committees that are sworn to secrecy for the information they get. Wyden can't talk about what he knows, but he hints at it. We have a secret court that has secret proceedings
that
with one
says that the fact that Congress was briefed in secret and didn't do anything is dispositive of their approval of the program.
Right. And later when we begin to see some of the redacted opinions, we see the qualms that the court has had about the level of information they've been given. So you have no oversight, and it magnifies the importance of having the press be able to get information that can then bring this to people's attention.
And at the same time, over the summer, I've been to God knows how many conferences all over the country, where the purpose of the conference with these reporters is, how do we keep them from knowing who we're talking to? What can we do? How do you when you've got people who are covering, the federal court and a school board in Omaha, trying to learn how to encrypt everything they do, things have gotten kind of nutty. And I think over the last 6 months, what's really become clear to me is we always viewed the press as being sort of the fourth estate, the other branch of government, the oversight function, everything. The balance of power has shifted, and I have never felt as a journalist so powerless in my life, because people are not talking. They are saying the risk is too high, and the fact of the matter is sometimes you need to protect a source, and the feeling out there is unless you are enormously sophisticated in the way you encrypt every single thing you do in your life, you're not going to be able to protect those people. And I think that's scary.
Right over here.
Hi, I think a journalist shield law is a great idea, but I also think for all the reasons you were just saying, it's going to be easier and easier for the government to find out who the source is without having to subpoena this information from a reporter. So in some ways, I think in most cases, a journalist shield law is not going to protect the source because the source can be identified some other way. And especially, I think in this administration, in this Justice Department, there's this kind of journalist good, leaker bad kind of dichotomy that they want to try to project. We would never prosecute a reporter, but we're going to put the leaker in jail for 1 million years. And it doesn't make a lot of sense because, I'm actually perfectly comfortable with some distinction between somebody who has taken an oath not to reveal classified information and a journalist who has not signed that kind of agreement. I think that's fine. But I don't think that's the end of the story, and I don't think it makes sense to have absolute protections for journalists, but then be putting leakers in jail for 35 years because they were revealing information that they believe should not have been classified, and given the state of overclassification, often they're going to be right. So my question is, given that the reporter shield law may not protect sources in most situations, what do you think, and I guess I'm going to ask this to Charlie just because I'm curious what you think about this. What do you think the is to protect the sources while simultaneously protecting the classified information that does need to be classified?
I guess it's a complicated question. I'm not sure who's the actor who's doing both of these things, right? On the protecting of sources side, this most recent case with the AP's source on the fact that a bomb plot had been foiled in Yemen is instructive in a variety of ways. But one of them is, if you take the government at its word, they knew who had the information on the inside. They interviewed 550 people over the course of a year, and they still came up empty. And it was only when they instead looked at who had the information on the outside, that is to say the reporter's metadata, that they were able to identify the source. And so to the extent that it becomes harder to subpoena telephone companies for a reporter's records, whether it's because of the new guidelines or because of a shield law of some type, that may be significant even though the data exists in the abstract. So I would say that. As far as how do we protect legitimate secrets, that's a huge problem, right? Because legitimate secrets are always in the eye of the beholder. I'm institutionally biased to say you have to trust reporters to be responsible and editors to be responsible users and not abusers of the First Amendment, because the alternative system is even more dysfunctional, which is to say the government can put people in jail for threatening to say something.
We have time for one more, and I think I saw one more hand. Is that? Oh, I see two more hands. Maybe we could do two more if you do it in 4 seconds each.
This question is for anybody who feels up to answering it. So one of my issues, I'm a reporter, and when I hear these arguments that the government makes about, national security interests, sometimes the national security interest seems very clear, but then sometimes, as in with these NSA disclosures, when there's, it was found out that they were spying on Germany, spying on Brazil, it's hard to see the national security. I mean, you can say national economic interest, okay, yeah, but national security, and who gets to arbitrate national security is something that I, as a reporter and also as a citizen, have issues with, and I'm wondering if you have any ideas about how that could be made, better.
Whoa. That's a big question.
That's a big question.
So one, it's a very difficult question because the timing is the problem, right? If it were things that we could assess in retrospect, if it were things that we could assess in hindsight, it would be very easy to say, oh, let's have adversarial process. We've gotten much better at secret courts, right? So we can have, in-camera proceedings, we can have security cleared counsel, we can do this all the right way. right? The problem is it never actually unfolds that way, right? It unfolds unilaterally. It unfolds with the government showing up and saying, there are compelling national security reasons, and not only can we not tell you what they are, we can't even tell you why we can't tell you what they are. And I guess, there has this, but I think this is why overclassification, if I can come back to sort of beating a dead horse, is such a problem, right? Because in a world where we had much more faith that government classification decisions were undertaken responsibly, that there was meaningful, and I won't sort of tease Ken, who has a new appointment, right, that gets to deal with some of this stuff.
Yeah, I'm going to resolve this whole issue.
Right, but I mean, in a world where we had more faith that there wasn't such pervasive overclassification, I think we, citizens, would be more willing to take the government at its word. When it says, listen, we can't really tell you why, but look at all these other things that we've been telling you about what we've been doing, have faith that, we have a good reason this time. And I actually think the most damaging byproduct of the Snowden disclosures has been to the government's credibility.
Yeah.
Because, Bradley Chelsea Manning is a different case because of the different nature of the disclosures. But, it's not just what was disclosed by Edward Snowden, it's all of the things that were disclosed that first people like Charlie had been fighting to disclose already. And second, in retrospect, we don't understand why they couldn't have been disclosed in their redacted form when they were handed down. And so I think, at the end of the day, the real answer to the how do we define national security conversation has to be we have to have a government that we trust to do it for us. And unless we do, I think the only way to attack it is by categorically going after the classification regime.
It's one of the interesting things about the Snowden case is for the first time that I remember ever, and I've been doing this for a long time, I was driving to work one morning and there was a Pew survey that came out and they were reporting on it. And I was blown away. 55% of the American public said they considered him to be a whistleblower, not a leaker. And that was the first time I remember something like that happened. I thought, whoa, the public is ticked off. This is a problem for the government.
Never mind that there are still serious debates about whether anything he disclosed is actually illegal, right? I mean, that's the remarkable thing about this conversation. So I think the credibility thing is a real problem.
That's funny, Lucy, because I was going to cite a First Amendment Center poll from around the same time that came out saying that only 14% of the respondents thought that the freedom of the press was an important right. So I think it's interesting how, and it kind of goes back to this.
I don't think they care about the press. I think they're ticked off that they were lied to.
Yep.
I think they take it very personally.
Yeah.
I don't think they care about the press, unfortunately.
I guess just to answer the question about who decides. I mean, as a constitutional and legal matter, it's vested in the executive to decide what should be classified. As a practical matter, I think this is where Steve is going. That's kind of the way it has to happen. I mean, because so much is, putting aside overclassification, so much classified information is generated every day by the intelligence community and the rest of the government that it can't go through some other process. It has to be classified by the people who are generating it in there in the executive branch. So that's sort of a simplistic answer. The reality is the system is prone to overclassification, and that's a reality. I mean, much too much is classified. Part of it's just, once again, very practical. You're generating a memo, and we saw some of these memos, that came out with WikiLeaks. Generate a memo that might have one or two facts that are secret, and then the whole memo gets classified. Mm-hmm. Well, no, it doesn't need to be. But the option is you have somebody in the bureaucracy has to go through and decide which fact is classified and which isn't. And it's just easier for that person to classify the whole thing.
And there's no disincentive.
Exactly. That's the next thing, is that it's much safer to classify the whole thing, because you're probably not going to be hurt for classifying it, but you might end up facing repercussions if you don't classify something that should be classified. So human nature is such that overclassification is a reality. It's a big issue. And I think it's a big issue just because we need to have a more transparent government, and President Obama came in making a push on this right out of the box. And I think much more needs to be done, but it also is a credibility issue. And yeah, you can agree or disagree about the legality of some of the things that were disclosed, but I think a lesson to be drawn from the whole Snowden thing is that, and I think folks inside the government would say this, that it would have been better to be a little bit more forthcoming with things, and maybe on some of these programs. I mean, people say, well, what, it's out there, and the terrorists haven't blown up the Capitol. Well, yeah, but we don't know the fact that a particular program is laid out, we don't know what use our adversaries are making of it. It's not evident to people who are not in the intelligence community what use they're making of it. So the fact that we don't have tangible evidence that a particular leak is being used by adversaries doesn't mean it's not happening. But the point is, I think it's clear that there were a lot of things that came out in the aftermath of the Snowden leaks that could have been sanitized and discussed openly without any real damage. And I think that's a lesson that the government has learned and will hopefully put to use later on, that, we can talk, especially when it comes to legal positions about, big programs.
Yeah.
We could talk about them in a sanitized way that doesn't divulge sources and methods. And at least the American public knows that that's an issue, that a court has decided it without getting in the details. There's going to be an element of trust there because not all of this can get out. But I think that is a lesson that's been learned, and in the meantime, I think credibility has taken a hit.
Just to throw one sentence on that, I know we have to wrap up, but I think an interesting question about whether a lesson that I think exists from this, just to build on something I was saying earlier, that I don't know that the government will learn, but is that the traditional national security investigative journalist activity, where you go to someone and a particular discrete piece of information comes out as a result for the public, is a safety valve, that there is surveillance without warrants in defiance of FISA is a discrete thing that the public needed to know about, and through traditional means, it did. When things get bottled up and that kind of source relationship with traditional mainstream media, even if it drives people like Gabe crazy, pressure builds up within the system that erupts in this new phenomenon, I would argue, of Manning and especially now Snowden, where it may be some particular thing they saw that they thought the public should know about, but because that old system is now being brought under pressure by this leak crackdown, instead, it erupts into 20,000 documents about everything. And it's going to be hard to convince the government with the safety valve that is not in compliance with the rules actually performs a function that when you remove that function, things can be far worse from the government's perspective. But I think that is true.
So I want to thank this really extraordinary panel for a fantastically interesting conversation. I want to congratulate our hosts on their blog. I want to urge you all to click on it 40 times tonight, over and over.
Only 40?
And I want to really thank you for being with us today.